Tonight, sparks fly in Supreme Court over controversial LGBTQ case as Chief Justice spars with lawyer for Speaker of Parliament Alban Bagbin. On day, the Attorney General made a push for the Apex Court to allow cameras within the court on a more regular basis.
Sorry.
No, my lady, I've got it right.
You can hear me very well.
Yes, my lady.
You appreciate the pickle we are in.
Yes, my lady.
You filed an affidavit on the 15th of... Please hold on.
Yeah,
Don't
yes,
interrupt me. Please.
Yes, my lady.
Always wait for me to lie.
Yeah, I'm not going to say.
We'll hear tonight from the Attorney General, who is making a case for the media.
To avoid any undue misrepresentation of facts is to ensure transparency. Let the public indeed have unhindered access to it. Proceedings to the court, of course, in terms of the Constitution and the Court Acts, are open to the public. But the public goes way beyond the number who can enter the courtroom.
More from the Supreme Court, which has asked Richard Sky to file a fresh motion for injunction and directing Speaker of Parliament's lawyers to withdraw some processes and file them again.
It's necessary to say this. Mr. Sorry, some of the material in your affidavit is extremely intemperate. Do well not to introduce such material.
I'm most grateful, my lady. Sometimes you respond to what comes from the other side.
This is Top Story with Evans Mensah.
Well, sparks went flying today in the Supreme Court over the controversial LGBTQ case, as the Chief Justice was left sparring with a lawyer for the Speaker of Parliament, Alban Bagbin. Well, it also happened on a day when we saw a strong push to allow the live telecast of high-profile cases that go before the courts to increase transparency. The Chief Justice accepted a recommendation by the Attorney General, Godfrey Adame, to allow a live telecast of the cases filed against the anti-LGBTQ case, now two of which were at the Supreme Court today. Godfrey Adame says this is crucial in the interest of transparency. More from the Attorney General pretty shortly, but first, member of our Legal Affairs Desk, Kweku Asante, sat through the proceedings, and many of you are now beginning to appreciate what has happened in court. And so I want to go through what we witnessed before the Supreme Court today, an unprecedented day, really. First time the cameras were let into the Supreme Court on the case which is not a presidential election petition. Kweku Asante is with me. So we expected this injunction application to be dealt with, but some technicalities came up. Why has Thaddeus Sorry, who, by the way, is a lawyer representing the Speaker of Parliament, been asked to withdraw his affidavit and file another one?
Well, so in some of the affidavits that were filed in court that had the seal of Thaddeus Sorry's law firm on it, the persons who deposed the affidavit used some pretty strong words in the opinion of lawyers for Dr. Amanda Odoi, and an opinion the Attorney General himself agreed with, and the Supreme Court ultimately also agreeing with. They were described as scandalous, intemperate. Those were the words that were used to describe these. And the court found favor in those arguments and asked Thaddeus Sorry to withdraw those processes that he had already filed in court, refile fresh ones that do not contain those words that have been described as scandalous.
It's necessary to say this. Mr. Sorry, some of the material in your affidavit is extremely intemperate. So I know they are not your affidavit, especially the affidavit of Mary Wendy Yeboah, which you have now withdrawn. Do well not to introduce such material.
I'm most grateful, my lady. Sometimes you respond to what comes from the other side. And that's the reason. But I'm taking cue. When they take a shot at you, you throw something back.
Had reservations about much of the language in the affidavits of your deponents, which carry the stamp of your law firm and your name.
Oh, is it
each of these affidavits has your name at the bottom.
Yes, my lady.
For instance, In the supplementary affidavit, this use of the language have deliberately, which paragraph is it? Have deliberately, paragraph 12, have deliberately suppressed the fact that the concerns raised by the letter which they flaunt before the court is intemperate. You're a very senior lawyer.
Yeah,
Mr. Ting, you're a very senior lawyer. What is particularly despicable and a definite desecration, just, you can hear me.
Very well,
Unless you want to do this. But I'm sure, that's why I say you're a very senior lawyer.
It was obvious at the start there that something was brewing between the Chief Justice and Tadio Sori. And we're not surprised later on when this blew up. It became almost like a standoff. At one point, the Chief Justice consistently, for at least a minute, asked him to sit down.
And Tadio Sori was on his feet for so many of those occasions because he wanted to make a certain point. And the Chief Justice wanted him to take a cue from the bench. He did not. He insisted on making the specifics of his case. It all came up when lawyers for Richard Alaska wanted to seek the leave of the court to amend their reliefs. Tadio Sori said that was irregular, and he was on his feet to oppose that. There was some back and forth between him and the Chief Justice who was presiding over the court.
I'm sorry.
No, my lady, I've got it right.
You can hear me very well.
Yes, my lady.
You appreciate the pickle we are in.
Yes, my lady.
You filed an affidavit on the 15th of... Please hold on. Don't interrupt me. Please.
Oh, yes, my lady.
Always wait for me to land.
Yeah, I'm not going to say it.
Your substantive application, affidavit before us, is dated the 2nd of April. Listen, let me land. If you had just waited to understand my words instead of rushing to justify yourself, you would have admitted that you didn't have a formal notice to object.
My lady, it's
a lawyer,
yes,
like yourself, you found yourself muddled up this morning.
Oh,
yes, you have. A lawyer files. I can see what his difficulty is. When you read, you can see he left out some words. You chose to denigrate that, what happened in his expressions, by describing it as muddled and confused. And the man now wants to correct himself by expressing it fully. And you say you have a preliminary legal objection.
Yes, my lady.
Where is the legality?
The legality lies in the fact that the motion paper invokes the jurisdiction of the court. And if there is an irregularity on the face of the motion paper, which I am pointing out as the foundation to which I am not accepting what he has filed.
No, hold on.
Yes.
Which motion paper?
His motion for injunction.
The man is not seeking... Hold on.
Yes.
Whenever I start, stop.
Oh.
You are going to interrupt me.
Very well.
Then you wouldn't hear what I have to say to you.
Very well, my lady. That once there's an objection taken to it, you cannot overreach that objection with a proposal to amend.
Hold on.
So that's all I'm drawing the attention to.
Stop there, Mr. Stop there.
Yes,
stop there. Now, if you had given a formal notice, anyone would have known. But in your affidavit, you only described your opinion.
No, what I found
that's not a preliminary legal objection.
Well, maybe it is not stated that it's stated as an opinion, but what I was stating what I found objectionable about it. And this court has also said that I don't even need that formal notice, that I can get up when he's about to move and take that preliminary objection. Trustees of the Synagogue Children of all nations. And the strain of them from the court that I didn't need.
Mr. Sorry, I'm not impressed by what you're doing.
Very well,
but just finish it.
I'm sorry. So,
finish it.
So I'm saying that
it's not fair to your friend. I don't think so. But you want to do it, do it.
I'm relying on the authorities from this court to take my preliminary objection, that I'm entitled to take it just when he's about to move it.
So just do it.
And my second point is that...
No, what is your first point?
Based on the practice that we all took you from in terms of the court's direction, the Attorney General filed no process indicating his objection to what is scandalous, what please matters of law, this morning, in order to enable us all prepared to come and take this point.
I beg your pardon.
There's a second point.
I will not note you down. Thank you.
There's a second point. The second point is that apart from saying they are scandalous and all, which are the words that are scandalous, which ones plead matters of law? So if my lady would, or if the court would exercise its
power. Can I manage my court?
Oh, I was just making a submission.
Can I manage my court?
Very well, my lady.
Thank you.
Well, I was just making submissions to assist the court.
Now, back to the decision to allow a live telecast. This was a big deal for us journalists. Yes. But what about the parties? How did they react?
Well, lawyer for Richard Alaska says he does not have any opposition to that idea. He believes that it will increase transparency. It will actually reduce the misreportage of court proceedings.
Our courts have nothing to hide, especially in this country. These constitutional matters are best placed in public domain so that everybody will hear and understand, to stop some of these speculations we have all around us. It puts an end to this making rounds of stories. We sometimes sound very strange when you are in court because they are not actually what happened. So I'm all yours when it comes to putting these things in the airspace for everybody to hear and see. It saves even us as lawyers because we belong to other social groupings and questions are asked every now and then about what transpired in court. So due to save me from the numerous explanations people may require from me.
But the AG wants more?
Yes, the Attorney General says the Chief Justice must actually relook at the decision where they do not allow live telecast of such cases. He says there's so many high-profile cases that continue to come to the court, both the Supreme Court and other courts. The court must aim towards the era where they allow a live telecast.
If you recall, about 2 years ago, one of my speeches to the Ghana Bar Association actually made a point that indeed, if the media were to have full and unhindered access to proceedings and all, it becomes so clear to the general public that when rulings are given by the court, they're actually on account of principles of law, and indeed most of the rulings of the court are right. I have suffered a lot personally in terms of the misrepresentation of court rulings and deliberate misrepresentation of what I say in court and what I do and all that. So I thought that the best way to avoid any undue misrepresentation of facts is to ensure transparency. Let the public indeed have unhindered access to it. Proceedings to the court, of course, in terms of the Constitution and the Court Acts, are open to the public. Well, the public goes way beyond the number who can enter the courtroom. So I think that a proper interpretation of the Constitution and all that would really require that when some of these politically sensitive matters and matters of enormous public interest come up for hearing, indeed, the media ought to have full access. It doesn't have to be only the presidential election petition, which occurs every 4 years or so, that the media should be able to cover. And I'm very, very grateful to Her Ladyship the Chief Justice for, in no time, acceding to my request and all. And I think that all I wanted to achieve was to ensure that people do not misrepresent what goes on in the court. They see exactly what went on. And today you saw it. So the process filed by some lawyers, very defective and all that. And indeed, in such circumstances, if the court were to rule against them, nobody should be surprised. Many a time, people lose on account of violations of the rules of court themselves, and then they go out there and say that justice or injustice was meted out to them. We see clearly arguments advanced by both parties for and against every application that is made in court, and of course, usually the court graciously, even sometimes, bends its way to overlook certain rules of the court and even allow the applications. And so we saw justice in action today.
Attorney General there, Godfrey Ibadame. Well, this case, in fact, the two cases, they all have to do with the LGBTQ bill. And remember that bill is a private member's bill. One of the sponsors of that bill, Roxing Nelson Defiamepo, joins us right now on the line. Himself a lawyer. Roxing, thanks for your time here on Top Story. You watched this unfold. You watched this unfold today. Your reaction?
Yes. First of all, we are in a hole. We are. The Public Accounts Committee, we are doing our regional tours and interrogating the Auditor General's report. So I couldn't get the opportunity to attend court, but I monitor proceedings. And you see, I love what happened today. Let's understand the history of our courts, especially the Supreme Court has been a very conservative one. So, but from about the time, for instance, when I began practice effectively from about 2010, there were moves towards making the court proceedings more open, more media friendly. And so we're hoping that by now, for instance, the court will have a well-functioning website where its proceedings could be monitored live from the website. The court by now should have a very active functioning Twitter account where decisions and rulings could be summarized by very highly trained court clerks who could summarize court proceedings quickly for the consumption of the public. The court, for instance, by now should have a well-functioning, well-set-up Facebook account where the court proceedings and whatever volumes of rulings that are turned out can be uploaded and received by the people. But what happened today is good. It's for the transparency of it. Everybody watched it. We saw what happened. Second, what troubled me is the fact that the speaker, who is a first defender in one of the matters, actually requested for expeditious hearing, and this happened late March. And today it's May. It's about the 8th day of May. So it's taking the court about 6 weeks to accede to a request for expeditious hearing to happen. And I thought that by practice, when such things happen, the court will be in a hurry to deal with the matter. So what does the court do by practice? They would have adjourned the matter to a definitive date. And then within that time frame, ask the parties to pin them to time, to filing the processes that they've directed them to file. So they could say that we are adjourning the matter to say the 30th of May. We are asking maybe the plaintiff, whatever process they want to file so within 4 days after today. And also upon service on the other parties, the defendant, if they are so minded, to also file 4 days after the service of the process. So by the time the parties and the court is returned to the agenda, there will be no processes outstanding. But what we saw is that the matters have been adjourned for the parties to put their house in order and come back.
Isn't it delaying the process?
And I thought that when the speaker as a party in a matter prays for expeditious hearing, it should matter.
But it's instructive, isn't it? The speaker's lawyer was there and never raised that subject.
Sorry?
The speaker's lawyer was in court today. He didn't raise that
subject.
Yes,
but I am making that observation that if I pray the court for expeditious hearing and it's taking about 6 weeks for that to be spun to life, it bothers me vis-a-vis when the Attorney General made the request to the court that my matter, for instance, be given expeditious hearing. You saw the alacrity with which it was handled. So I'm just opposing these two matters and placing them in context and making this analysis. But be it as it may, we hope that the processes will be quickly filed, and then the court could be set. Then hearing notice will be issued, and then we can return to court quickly.
And whilst this process is ongoing, everybody's watching this unfold very, very closely. Now there's transparency. We're going to be in court. You raise the subject of the indefinite nature of the adjournment. But if you look at what transpired today, though, on the objections that were raised, the rulings that came, you clearly see that, do you not, that the judges are really in charge of what is happening, and they attach a significant degree of seriousness to it, for which reason they've made an exception for the live coverage.
No, but we speak of the Supreme Court. With all due respect and with all, for want of a better expression, we are not speaking of proceedings before any other lower court but the Supreme Court. This is where the best law, the best reasoning in the law, the best jurisprudence is espoused. And so the judges, of course, are always in charge of what happens in our court, and especially the Supreme Court. So I am fine, but just that my observation is in respect of the matters that I raised before you, that I thought that they could have adjourned to a definitive day within which the parties could have put their house in order and filed the necessary process. And then when that date comes, the court would have made a determination.
Roxy Nelson Defemepo, thank you very much. He is a co-sponsor of the Anti-LGBTQ bill, which is a subject now of that Supreme Court hearing. I want to bring in right now Suleiman Abraham, he's Executive Director of the Media Foundation for West Africa. Albert Kwabena Jumfo is a GJA president. As you've just heard there, Roxy Defemepo makes the point that the decision by the Chief Justice to agree that we can put the cameras in that call so we can bring you live coverage is one that needs to continue. The Attorney General is actually pushing that this becomes the norm. I'm grateful, Suleiman Abraham, for your time and Albert Jumfo too. So let me start with you. I mean, we all watched this unfold. We've not seen this before if it wasn't the election petition case. Do you agree at least with the Attorney General who says we should make this a standard practice in our courts now? When there's a huge matter of national interest, allow the media in and allow the cameras in too.
Well, Evans, I think that is a good call. The question or the debate about whether cameras should be allowed in the courtrooms is a long-standing debate. In the U.S., for example, there are very serious proponents who say, look, matters happening in the courtrooms are of public interest, and therefore, whatever steps that can be taken to ensure that the public have full access to deliberations should be put in place. But there are also others who strongly oppose that view with reasons including the fact that, look, there are some judges who may not be comfortable with cameras. There are witnesses who would appear, and if there are cameras, they will feel jittery. And others have said, look, the inclusion or the presence of cameras have led to witnesses behaving in a certain way that then reduces their credibility before judges and so on. And in fact, in the U.S., there have been a case, I think it was 1964 or 54, where eventually a case was overturned by the Supreme Court, and the main basis was the fact that there was camera presence that affected, the testimonies and the behavior of other people. And so eventually the case was overturned. But since then, I think that there have been some progress. In a number of states in the U.S., they say, well, cameras can be allowed in very high-profile cases. And if you look at the UK Supreme Court, which surprisingly, is a very recent establishment, replacing what they had, which was an appellate cause of the House of the Lords or something like that. Since 2009, they have installed cameras in the courtrooms to say, look, we want all cases recorded, and the recordings are made available to the public, because whatever we are doing is in the interest of the public. The public must know, they must follow it. But I think that still doesn't take away the fact that, look, there are witnesses who would not be comfortable with cameras. There are judges who would not be comfortable with cameras. Others have said some lawyers, once there are cameras, would even grandstand in the courtroom and behave in certain ways that, undermine court protocols and so on and so forth. In our context, I think that is a good thing, at least for high-profile cases of this nature. It will be good to have, live coverage as we are having in this case, or the elections petition. But that, I believe, also imposes some responsibility on us, the media, on how do we present these things or capture these things to our audiences in such a way that it's professional, it doesn't affect the processes in court, and it doesn't, present any situation where judges may say, well, if we continue this, it is going to undermine justice delivery in our country. So there are pros and cons, but I think that I'm for it, at least for high-profile cases.
And Albert Jumfo, the president of the GJ, you agree with that?
Okay, I think that Evans, for me, yes, I totally agree with your question that this is really is a good one for Ghana's democracy. I have mentioned this morning in Joy News that look, the public is supposed, or the public is entitled to whatever happens in our court, because the court is a public place, and for that matter, whatever happens is for the public good. And you see, we find ourselves in a state, in a country where there's so much suspicion, where there's some kind of doubt, even in our judicial system. People could therefore sit back and then, should I say, suggest or make conclusions of ruling of a case, and it will come to pass. It will be the same thing. And so, if we have not only high-profile cases or constitutional cases, this is a matter that has generated public discourse, public interest in the past few weeks or the past few months. It has really even created what we call the power play between the executive and the legislature. This is a matter of interest. This is a matter where we feel that the larger or maybe the Ghanaian community are all interested to actually know as to whether Parliament really did what is right or Parliament did not do what is right. And for me, I think there's no argument. It helps to deepen our democracy. It helps to also inform the citizens. Citizens get to know whatever. It could be that, from what my good brother Sule said, they could face cameras, or should I say, is there secret cameras in the courtroom that could record proceedings that wouldn't really be visible to actually create some kind of maybe fear or hatred in witnesses and so whatsoever. And once it is done, we could have access to a server that will help us stream live through national television or whatever media platform. That could be done. Maybe the fact that maybe cameras are fake there. Sometimes when people are before cameras, they become jacketed, which I agree with him on that. We can do it in such a way that people will not even feel the presence of cameras, but yet the citizens and the public will still get to see, get to view, get to watch whatever transpires there. For me, it's really a good cause. It is for a good reason, and it's for the good of the people of this country. Because even in this era, when we have RTI Act or law, we're still struggling to access or get information. There are instances where even judgment or maybe cases, you want to get ruling on particular cases, you even apply and you will still find it difficult to get it. And so when such cases of interest, such cases of national interest for that matter, come up and the media is discussing, or maybe the public wants to know whatever transpires, I believe if we make it public and we follow
as
procedures.
It is now, it's been applied on a case-by-case basis, but the argument is we need to get to a place where this is the norm. That will require...
Can you please come again?
Just a second. I'm making the point, if you can hear me, that as it is now, there is a real push and a real desire now to get this to become the norm. Instead of being applied on a case-by-case basis. That will require some level of advocacy, right? From the GJA's point of view, I mean, the Attorney General has hinted that this is something that he requires. Are you ready to partner him and make this
We will
advocacy?
fully support the Attorney General on this course. The GJA will not hesitate supporting the Attorney General. I said it's a good cause. For us, anything in the interest of the public. As a fourth estate, what is our role? One of our role is to be the watchdogs of the people's rights. And if the public really is interested in such a matter, as I indicated, aside constitutional matters and other things, this matter has generated national discussion, national discourse on whatsoever. And so, and it has even created some kind of hard blood between the executive and the legislature. We've seen the exchanges, and we've seen even a call from the majority calling on the speaker to reconvene parliament and all that, and the brouhaha. It's all due to this cause. So I believe that this is a matter of national interest. And for me, aside that, if we want to make all high-profile cases or all other cases public, we want to, like what the Attorney General is saying, you want to lead the charge and engage the Chief Justice to make sure that at least it becomes, is it whether a convention or a law or whatever, which is acceptable by the people or by all stakeholders, we will support this advocacy. And I can tell you that it will really help to eradicate the kind of doubt, should I say, doubt people have in our court. There's so much doubt. People,
and you're right on that. And just a quick word to Sule. Sule, Do you raise a point about responsibility? Once we embark on this particular journey, advocacy is brought to bear, and this becomes a norm. Are you confident that the Ghanaian media is mature enough to have this become a norm that will not be abused? Because we've seen in the past, and the reports are abound, that irresponsibility is still an issue that is flagged in a lot of the media reports. You think we are ready, Sule?
Well, Evans, I think that it's an important conversation to have, but we need to also be very real. The courtrooms are not, let's say, places like Parliament. Courtrooms are about law, about evidence, and so on. And those of us who are non-lawyers, sometimes we look at issues from logical point of view, from what makes common sense and all of that. But lawyers will tell you it's not about what is emotionally appealing, what is, values on face value quite attractive, and so on. And so if you look at the elections petitions, the two of them, and I believe even in this case, the decision has been that, yes, live stream or live coverage, but it must be GBC, and then others can pick feed from GBC. I think it's a cautionary step that is taken to ensure that the processes are well guided. If we want to get to a point where we say it becomes a norm, whether at the Supreme Court, Appeals Court, High Court, if the media are willing and interested to come and cover issues live, the courts are happy to do so. It will also mean that we need to have proper conversations, proper processes on what steps must be taken. Agreements must be reached between what is allowed within the realms of the judiciary and what the media can do and what our ethics would allow. I don't think that it will be proper for all of us to just say, okay, yes, advocacy, let all courtrooms be open to media, and then we say from next month, every court case, the media can go there and cover it. Remember that we are in a country where when people are being prosecuted, before you realize it is given a political twist. Oh, so this person is doing this because he's an MPP person or he's an NDC person, or a judge is branded an NDC judge, an MPP judge, a lawyer is MPP lawyer, NDC lawyer. I think we have to come to a point where we say, look, the law is the law. It is not about MPP or NDC, because our media is highly polarized, and you cannot vouch for what people would do. And in order not to undermine justice delivery, and in order to ensure that our justice system would be one that we all would trust, yes, it will be good to have the cameras in the courtrooms, but we need to, first of all, get the fundamental processes outlined.
Sule, thank you very much. It's Suleiman Ibrahima, the Executive Director of the Media Foundation for West Africa, Albert Kwabena for GJA President. Still ahead here on News Night.